This is claim number F1812-70, the case of Budd and Blackpool. Do I have Mr. Hill for the claimant?
Yes, sir.
And Ms. McKinley for the defendant?
Yes, sir.
And do we also have the parties present? Ms. Budd, are you there?
Yes.
And Mr. Blackpool?
I am.
Grateful for that. My name is District Judge Made-up. I'll be dealing with the hearing today. The matters listed for fast-track trial. One or two matters I'd just like to confirm before we get started. First of all, can counsel confirm that the parties have consented to this being dealt with by way of this remote hearing?
They have, sir, yes.
Yes, sir.
And do the parties have bundles available to them for use during the course of this hearing?
Yes, sir.
Yes, sir.
And have arrangements been put in place to ensure that the parties can give instructions to their counsel during the hearing?
They have, sir, yes.
Yes, sir.
Thank you. Now, evidence will be given on affirmation. Obviously, just one point I should make clear to the parties themselves. Your evidence must be your own. There's no rule against other people being present in the room with you as you do give your evidence, but they mustn't assist you, remind you, coach you in relation to the evidence that you're giving. And I want the parties to confirm personally, please, that they understand what that means, what I've just said. Ms. Budd, do you follow?
Yes, sir.
And Mr. Blackpool?
I do. Thank you.
Thank you. Now, I've noticed from the case summary that there's a very large measure of agreements in relation to quantum. There's a small dispute about miscellaneous expenses, but that won't take up a lot of our time. The issue is straightforward, it seems to me, Mr. Hill. I've read the witness statements. I've read the documents attached. I don't require a formal opening unless there's anything in particular you'd like to raise with me.
No, thank you, sir. If I may just call the claimant Ms. Budd.
Of course. Now, Ms. Budd, are you there?
I am.
I'm grateful. Just before we start, could I just remind those who won't be taking an active part in the giving of evidence whilst Ms. Budd is giving her evidence to turn off the microphone. So that applies to you more than anyone else, Mr. Blackpool. If you could mute your microphone while Ms. Budd is giving her evidence. And Ms. Budd, when we come to Mr. Blackpool's evidence, perhaps you can mute your microphone then. Now, Ms. Budd, you'll be giving your evidence on affirmation, so perhaps you could just repeat these words after me. I do solemnly, sincerely and truly.
I do solemnly, sincerely and truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you. Mr. Hill.
Thank you. Ms. Budd, could you turn to page 28 in the trial bundle that you have there?
Certainly.
And do you see a document there entitled Claimant's First Witness Statement?
I do.
And if you turn through that document, through 29, 30 to page 31, do you recognise that document as your witness statement?
I do.
And the signature on page 31, do you see that?
Yes, that's mine.
It is. Before you signed the document, were you satisfied that its contents were true and accurate to the best of your knowledge and belief?
Yes.
And do they remain so true today?
Yes.
So if that may stand as the evidence in chief.
Of course. Ms. McKinley.
Thank you, sir. Ms. Budd, on the day of the accident, it was the 1st of December 2018, you were going to an important meeting with a client, weren't you?
Yes, it was a new customer.
And that meeting was due to start at 2:30 p.m, is that right?
Yeah.
But you didn't reach the junction between Havisham Lane and Kelsall Road until 2:35 p.m, did you?
Yeah.
So you were already running late for your meeting?
A little bit, yes. You didn't know the way to this client's address yourself. You hadn't been before, had you? No, I'd looked on Google the night before.
And you were relying on your sat-nav. You've told
Yeah.
us that in your statement.
Yeah.
Your sat-nav's positioned in your dashboard, isn't it? So it's to the centre of your vehicle, a little bit down from your steering wheel. Is that right?
Yeah.
And you'd need to look down towards the sat-nav to look at it, wouldn't you?
Yes, on occasion.
When you got to the junction between Havisham Lane and Kelsall Road, you were stationary for about 30 seconds. Is that right?
As long as it took me to do my checks right, left and right again.
Well, it wouldn't take you 30 seconds to do checks right, left and right, would it, Miss Budd?
It didn't feel that long.
Well, you've seen the statement of Mr. Blackpool, and you know he says you were stationary for about 30 seconds.
Yeah.
You were looking down. Was that at your sat-nav or at your phone?
No, it certainly wasn't my phone. I may have glanced at my sat-nav, but it was literally a glance, if anything.
Well, you were looking down at the point that the collision occurred, weren't you?
No.
You've told us in your statement that when you felt the collision, you felt your vehicle was shunted forwards. Is that right?
Yes, that's right.
You've got the bundle there with you, haven't you, Ms. Budd?
I have.
If I could ask you to turn to page 33 in the bundle.
Yes.
There's a photograph there, isn't there?
Yes.
Was that taken by you?
Yes, on my phone.
And that was taken immediately after the accident, wasn't it?
That's right.
And you can see in those photographs, Miss Budd, the vehicles look to be touching, don't they?
Well, it looks like they are, but I don't think they are.
Well, that's certainly what's shown in the photographs that you took after the accident, isn't it?
Yes.
If those vehicles were touching or nearly touching, your vehicle can't have been shunted forwards, can it?
Well, it definitely felt like it was shunted by him.
But you would accept that's not shown in those photographs.
I guess not.
This junction's on a slight incline, isn't it?
No, it's flat.
Well, Miss Budd, you've only been there once, momentarily, immediately after an accident. It's very difficult to recall whether it's flat or not. Mr. Blackpool, you'll have seen his statement, says it's on a slight incline.
Well, if it is, it's barely an incline.
The reason, Ms. Budd, that those photographs show the vehicles touching is because you just rolled back into collision with Mr. Blackpool. That's right, isn't it?
No, definitely not. He shunted me.
You were distracted and you moved or rolled your vehicle backwards.
No.
The damage to your vehicle is limited to the number plate and the bumper, isn't it?
Yes.
And you can see on the photographs there was very little damage to Mr. Blackpool's vehicle, wasn't there?
Relatively, yes, I guess so.
And the reason, again, that the damage was so limited was because this was a very low level, low impact collision when you moved or rolled your vehicle backwards into collision with Mr. Blackpool. That's right, isn't it?
No, it certainly didn't feel like that.
Thank you, Ms. Budd. Thank you, sir. No further questions.
Thank you. Any re-examination?
No, thank you, sir.
And I think that concludes the case for the claimant. Is that right, Mr. Hill?
It is. That is the claimant's case, sir, along with, of course, the exhibits to the witness statement and, of course, the medical report.
Which I've seen. Thank you for that. Right, Ms. McKinley.
Thank you, sir. If I could call Mr. Blackpool.
Certainly. Mr. Blackpool, are you there? You heard the words of the affirmation. Perhaps you could also repeat them after me. I do solemnly, sincerely and truly declare and affirm.
I do solemnly, sincerely, truly declare and affirm.
That the evidence I shall give shall be the truth.
Yeah, that the evidence I shall give shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you for that. Yes, Ms. McKinley.
Thank you, sir. Mr. Blackpool, please could you confirm your full name and address to the court?
Yeah, I'm Stephen Blackpool. I live at Pickwick Road in Heap in Cheshire.
Sorry, Mr. Blackpool, you just paused for a minute. Could you repeat the address, please?
Sorry, yeah, it's Bleak House, Pickwick Road in Heap in Cheshire.
Thank you, Mr. Blackpool. You've got the bundle there. I wonder if you could turn to page 39 in the bundle.
Yeah, I have that now.
There's a statement starting at page 39 and going through to page 41. And there's a signature on page 41. Is that your signature?
It is.
And have you had the opportunity of reading through that statement before coming on to this hearing?
I have.
Are you satisfied that the contents of that statement are true to the best of your knowledge and belief?
I am.
So if that could stand as Mr. Blackpool's evidence in chief, please.
Certainly. Mr. Hill.
Thank you, sir. Mr. Blackpool, as you were driving along, you had your daughter as your front seat passenger, didn't you?
Yeah, that's correct.
And you were having a conversation with her, weren't you?
Yes.
And when you talk to somebody, you tend to look at them, don't you?
Not when I'm driving, I don't know.
Now, Mr. Blackpool, it's your case, isn't it, that you could see the claimant looking down at her mobile phone?
Yeah, that's right.
Now, I'm just going to share on screen with you now page 36 of the bundle, which is the photographs that were taken immediately afterwards. Do you see that photograph on your screen now?
It hasn't come up just yet. Okay, yeah, I can see it now.
You can. And you can see in that photograph that there are headrests to the claimant's car, can't you?
Yes.
And you can also see, Mr. Blackpool, if I move to page 33 of the bundle, that the claimant's car is much lower down than your car, isn't it?
Yes.
And indeed, her back window is about at the level of your bonnet, isn't it?
It is.
So, from your driving position, you wouldn't have been able to see into her car, would you?
I could. That photograph doesn't do it justice because, of course, she moved backwards by then, but I could see her.
Now, Mr. Blackpool, you say that the claimant moved backwards into your car, don't you?
Yeah, whether she reversed or whether she rolled, I'm not entirely sure, but she definitely moved backwards.
Well, you don't say that you saw any reverse lights.
No, but I don't recall whether I saw any reverse lights.
So if there were no reverse lights, it must be that she just rolled backwards, mustn't it?
Well, I just can't recall seeing reverse lights.
Now, the problem with that, Mr. Blackpool, is that Havisham Lane's not on an incline, is it? It's a flat piece of road.
No, that's not right. There is actually an incline there.
And also, the claimant's car is an automatic. So if she did inadvertently take her foot off the foot brake, she wouldn't roll backwards into you, would she?
I've never had an automatic car. I don't know whether that's correct or not.
Mr. Blackpool, I suggest to you that the reality is you were driving along talking to your daughter and you were distracted, weren't you?
No, that's not true.
You were not paying attention to the road ahead, and as a result, you drove into collision with the rear of the claimant's stationary car, didn't you?
No, I was stationary and her car moved back towards mine and collided with it.
Thank you, sir. I have no further questions for the witness.
Thank you. Is there any re-examination?
No, thank you, sir.
I think that concludes the defendant's case. Is that right, Ms. McKinley?
It is, along with the assessor's report that is exhibited to Mr. Blackpool's statement within the bundle.
And that's the document which I read earlier on. Submissions, Ms. McKinley.
Thank you, sir. Sir, I've no need to remind you of the balanced probabilities or that the burden in this claim rests upon the claimant. There are diametrically opposed accounts, and this is a case without independent witness evidence. You've heard the oral evidence of both parties. In my submission, the defendant was consistent, he was detailed, and he was clear in his recollection. That has to be compared with the claimant's own evidence. She now accepts, despite her assertions in her witness statement, that she was running late for an important meeting. She accepts that she was entirely unaware of where she was going and that she was entirely reliant on her sat-nav. The defendant's evidence is that he was positioned behind her for 30 seconds, and the claimant accepts that she may, at least for a portion of that time, have been looking down towards her sat-nav. This is a defendant who knows this junction well. He'd stopped a reasonable distance behind, and he was stationary there for some time when the claimant, who was distracted, reversed or rolled her vehicle backwards. So in my submission, that is entirely consistent with the only two bits of independent evidence that you do have. There's the photographs appended to Ms. Budd's statement. They were taken immediately after the accident, and they show the vehicles touching. In my submission, that is clearly inconsistent with the claimant's account, where she says her vehicle was shunted forwards, and it is only consistent with a very low level minor collision, which would be the claimant rolling or moving her vehicle backwards. That's also, in my submission, sir, consistent with the low level damage. You've seen the invoice for the repairs to Ms. Budd's vehicle. You've seen the assessor's report for Mr. Blackpool's vehicle. This is light damage. It was limited to the number plates and the bumpers. In my submission, so you shouldn't be misled by the cost, where these are both luxury vehicles, both being Lexus vehicles. And again, so in my submission, that damage is only consistent with a light impact as described by Mr. Blackpool. So those are my submissions in respect of liability. In relation to quantum, the parties are virtually agreed. The only issue is in relation to miscellaneous expenses. You'll note the claim for £25. The defendant offers 10. There's no evidence in respect of that before the court, and I'm really within your hands in respect of that, sir. But unless there's anything else, those are my submissions.
No, thank you, Ms. McKinley. Mr. Hill.
Thank you, sir. Perhaps unsurprisingly, I ask you to prefer the account of the claimant, but I say I do so for very sound reasons. The first is the plausibility of the various accounts that have been given. The claimant's case is clear and straightforward. She contends that what occurred on that day was a simple rear-end shunt. That is an inherently plausible state of affairs, and one which this court will no doubt be familiar with. What the claimant says is likely is that the defendant, whilst distracted, perhaps due to the conversation he was having with his daughter, merely didn't see her and drove into the rear of her vehicle. The claimant has been consistent in her account throughout. She accepts quite properly that she was reliant upon her satellite navigation system, a point which the defendant takes, but I say nothing turns on because it doesn't explain a rolling backwards. And further, sir, I say the damage supports the claimant's version of events because, of course, a new bumper was required to the claimant's car. That, I say, is far more consistent with a rear impact, as the claimant describes, and is not inconsistent with a mere rolling back over just some 12 inches. In relation to the defendant's account, I say that ought to be rejected, sir, and I say upon proper examination it is somewhat dubious. Firstly, the contention that the defendant could see the claimant on her phone ought to be rejected. From the size and positioning of both motor vehicles, it's highly unlikely, I say, that the defendant would have been able to see into the claimant's car. As to the fundamental suggestion that the claimant moved backwards, I say that can be rejected, firstly because Havisham Lane is not on an incline, or if it is, it's a very, very slight incline. But more instructively is the fact that the claimant was driving an automatic vehicle. So even if she did take her foot off the foot brake momentarily, her vehicle would not move backwards, but stay stationary. Accordingly, sir, I invite you to enter judgment for the claimant for the amount agreed, save for that small issue in relation to miscellaneous expenses, which I don't intend to address you on, unless it may assist you further, sir.
No, thank you, Mr. Hill. Yes, I'll deliver my judgment now. This is a claim which arises out of a road traffic accident which occurred on Havisham Lane in Cheshire on the 1st of December 2018. There's no dispute that the front of the defendant's vehicle was in contact with the rear of the claimant's vehicle. The dispute concerns how that state of affairs came about. The claimant says that she was intending to drive onto the main Kelsall Lane had become stationary at the junction, and as she remained stationary there, the defendant simply drove into collision with the rear of her vehicle. The defendant says that's not right. He says that he was behind the claimant's vehicle, but he was stationary around a foot behind the claimant's vehicle for a time when the claimant reversed or rolled backwards a distance of around a foot into collision with the front of his car. It's for the claimant, of course, to prove her case on the balance of probabilities, and it's for me to decide on the evidence I have heard which version of events is to be preferred. I've come to the conclusion that the claimant's account is to be preferred and that the claim should therefore succeed, and my reasons are as follows. First of all, I accept the claimant's account, her unchallenged account, that she was intending to turn right onto the main road, and that was always her intention, and she would therefore have had no earthly reason to reverse back onto Havisham Lane. And I reject any suggestion that she did so. As to the alternative suggestion that she rolled backwards inadvertently, I reject that argument as well for two reasons. First of all, there is no incline, or at any rate, a very minor incline, if any, at the locus. I can see that from the photographs. Secondly, and importantly, she was driving an automatic vehicle, so even if she did take her foot off the brake inadvertently, the vehicle wouldn't have rolled backwards. Now, neither party suggests an apportionment, and an apportionment wouldn't be appropriate, so the claim succeeds, in my judgment, to the extent of 100%. I should perhaps mention, although I don't attach a lot of importance to it, the damage to the vehicles. Counsel has made the point that the damage which is evident from the repair documentation is inconsistent with the claimant's account. I haven't got the benefit of Part 35 evidence. I only have the repair documentation, so this doesn't guide my decision. But for what it's worth, having seen the repair documentation, I don't consider that it shows damage which would be consistent with a rollback over a distance of only 12 inches from a standing start. Those are my reasons. That's my decision. There will be judgment for the claimant. I've seen that there's a very large measure of agreement. The only area, in fact, in which there's disagreement in relation to quantum is in relation to miscellaneous expenses, and both counsel have very sensibly not sought to address me at length on that. I award £15 under that head. Taking the agreed heads from the case summary and adding the £15, if my maths is correct, brings the judgment figure to £4,009.25. I'm assuming that the agreed figures are inclusive of interest unless anybody is going to tell me otherwise. That will be the judgment sum. Costs.
Thank you, sir. All sums are inclusive of interest. In terms of costs, it's a fixed cost matter, and the fixed costs are calculated in the total sum of £4,367.85, including all disbursements.
Thank you. Is that figure agreed, Ms. McKinley?
It is, sir, yes.
Thank you. Right, well, I'll make an order in those terms. Are there any other matters?
No, thank you, sir.
No, thank you, sir.
All that then remains is for me to thank counsel and the parties for the extremely efficient manner in which the trial has been conducted, and to wish you all a very good morning. The hearing will now terminate.